in the matter of Last Maritime and another, and Smit Salvage and others.
Yes.
Good morning, my ladies and my lords. In this appeal, I act for the appellants, together with my learned friend, Mr. Nigel Jacobs, and Ms. Caroline Pounds, and my learned friend, Mr. Jonathan Gaisman, acts for the respondents, together with Ms. Blackburn and Mr. Carruth.
Yes, thank you.
This is an appeal from the order of Mr. Justice Baker, dated the 30th of March 2023, in which he declared that no contract in respect of salvage services was concluded between the parties, as had been pleaded by the appellants in their defence to a claim for common law or convention salvage remuneration. By way of background shortly, this case arises out of the high-profile grounding of the MV Ever Given in the Suez Canal on the 23rd of March 2021. It led to many news items. The court may have seen it on the BBC News. This very large container ship blocking the Suez Canal for some period, causing a major pile-up of traffic behind it and shortages as a result. And in the judgment on paragraph 2, there is the photograph that is seen in many of the news items showing the
We
vessel.
were just admiring it before we came in.
Yes. The salvage, as you will have seen from the judgment, was controlled by the Suez Canal Authority, the SCA, which, as the judge found in paragraph 3 of his judgment, took control of any salvage that took place within Suez Canal. And one of the challenges was to liaise with the SCA in respect of any reflotation attempt. Reflotation attempts continued from the 24th of March, after the vessel went aground on the 23rd. And you will have seen from the judgment that 2 tugs hired by the first respondents, Smits, who are a very well-known international firm of salvors, arrived in the morning of the 29th of March, so some 6 days after the grounding. And the vessel refloated at 13:05 UTC on Monday, the 29th of March. And when we look at the dates, it's important to bear in mind that the 29th was a Monday and the 26th was a Friday, with the weekend in between. And I'll show you the timing shortly. The respondents, whose tugs were part of the reflotation, claim for salvage under the terms of the International Convention on Salvage, 1989, and in particular Article 13 of that convention, or common law. And there are certain features of the English law of salvage and under the Salvage Convention which the court needs to bear in mind when looking at some of the underlying correspondence. Underlying the claim for common law salvage and a claim under the convention is the concept of no cure, no pay. If you attempt salvage without success, you get nothing. There is no right to quantum merit in respect of a failed salvage attempt. If you are successful, the remuneration under the common law and the Salvage Convention is calculated by reference to the total value of the salved fund, which would be the ship, the cargo, in this case containers and the cargo within it, the bunkers. So that's the salved fund. The next feature is the dangers to which that fund is exposed. So if, for example, you have a grounding where there's a risk of a total loss of the vessel, if there hadn't been a successful salvage, you will get a higher sum as part of your salvage remuneration than if the vessel was simply immobilized, i.e. aground, but with no risk of structural damage. The next feature that feeds in is the services provided by the salvor. So in this case, where you will have a number of different people involved, you look at what contribution you provided to the rescue. So you might have, for example, 3 different firms providing 3 different tugs, and you would have to work out which tugs provided the most assistance. That goes into the mix. And linked to that is the resources committed, which is sometimes called the out-of-pockets. In many cases, as part of the salvage claim, the salvor will inform the court or tribunal the amount is expended. It doesn't have to, but normally it will do so. And the salvage reward will take into account the amount that's been expended. And lastly, the status of the salvor. A professional salvor will get more than without being pejorative, an amateur salvor, because the professional has invested resources into building up its capability. So that's what happens if you're successful. If you're not successful, you get nothing. Owners in this case deny the claim on the basis that Smit services were provided under a contract which was concluded on Friday the 26th of March 2021. If that is right, then Smit has no claim for salvage remuneration under the convention or common law. Its claim is to claim in accordance with the agreed contract between the parties. And as regard the alleged agreement relied on by the owners, the judge found in paragraph 29 of his judgment that there was neither uncertainty as to what was agreed and not agreed, nor insufficiency in principle in what was agreed, if taken by itself to be capable of being a contract. The contract formation issue is intention to be bound. And therefore, the sole question before the judge and on appeal was whether or not the parties' agreement to the principal or main terms set out in the exchange on Friday, the 26th of March 2021, was intended to be legally binding, or whether the parties only intended to be bound once they had reached agreement as to further detailed terms. The judge's conclusion was that the parties did not intend to be bound unless and until they agreed a detailed set of terms based on the Rec Hire 2010 form that they were still in the process of negotiating at the time of the reflotation. Permission to appeal was granted by Lord Justice Phillips in respect of one of the two proposed grounds of appeal, namely that there had been an error of law in the construction of the exchanges leading up to the conclusion of the contract. Permission was granted on the basis that it was sufficiently arguable that the relevant email exchanges between the parties did disclose a binding contract, given in particular Smith's threat to stand down salvage services if agreement was not reached by 12 noon Dutch time, which is 11 AM UTC or 8 PM in Japan. When looking at the times in this case, it's important to bear in mind that although the times on the exchanges and in the appendix to the judgment are given in UTC, which is the same as GMT, and Captain Sen, who may have seen in the exchanges, is based in London, the insurers are in Japan, which is 9 hours ahead. And the court will find the agreed times at the top of the appendix to the judgment in the core bundle at page 77. You can actually see there all the times that the judge has found. And it is important to bear in mind when looking at the exchanges what time it was both at the site in Egypt and in Japan and in Holland and London, because noon in Holland is 11 AM in London, but 8 PM in Japan. So the summary of our appeal is quite simple. At the heart of our appeal are the three ultimatums given by Smit on the morning of the 26th of March. The ultimatum on the morning of the 26th of March is dealt with quite briefly in the judgment of paragraphs 64 and 76. And in our submission, the judge did not focus on the precise wording of the ultimatums in his judgment, only one of the three ultimatums is quoted in the judgment itself, but not in full. He doesn't refer to the other two in the judgment, though they are quoted in the chronology attached as the appendix to the judgment as items A77 on page 97 and A91 on page 100. And we say that the judge was wrong and fell into error in 7 respects, which I will then develop. First, he did not consider properly the wording of all 3 ultimatums in his judgment, which were given in response to the owner's request for Smit to contractually engage 2 tugs for the salvage services. Second, he failed to consider properly the salvage context in which these ultimatums were given. The fact that owners were refusing to agree on terms, and that Smit was exposed to the risk of substantial expenditure in hiring tugs without any assurance that they would be paid in the event that a reflotation happened before the tugs arrived. Third, he failed to consider the timing, both as between the parties and in the context of the salvage services that needed to be rendered. Fourth, he failed against the background of the ultimatums to give sufficient weight to the contractual wording of the exchanges between the parties following the ultimatums. And the use of language such as agree, offer, acceptance, confirmation, reconfirmation, and cancel. Fifth, he failed to consider the terms of the exchange between the parties in relation to the reflotation bonus, which only makes sense if the agreement between the parties is to have immediate contractual force. Sixth, he failed to note the complete change of tone or tenor in the exchanges, or lack of exchanges, after noon on the 26th. Notwithstanding that on Smit's case, they remained as exposed as they were on the morning of the 26th. The tugs did not arrive on site until the 29th, and yet we see no further ultimatums and no sense of urgency to conclude the wreck hire negotiations. If the ultimatums, of which there are 3 on the 26th, was because Smits were concerned to ensure that they would be paid for the tugs, if there was no agreement on the 26th, they remained as exposed for the rest of the 26th, all of the 27th, and all of the 28th. And yet we see no further ultimatums during that period. And finally, the judge failed to give sufficient weight to the fact that following those communications, Smit performed the very request that had led to the ultimatums. They did not demobilise tugs or personnel. They engaged the tugs and committed them to the casualty, and they did so with the assurance, the promise, or the contractual agreement that they would get paid at the rates agreed on the 26th of March. That is the shape of the appeal. My lady, my lords, what I propose to do, just give you a route map of what I'm going to do. I'm going to briefly touch on the law of main terms contracts. I won't take very long on that because I don't think that's in dispute, but I'll just remind you of the key points. We've marked up the relevant passages, but I'll do that quite shortly. Then what I propose to do is identify the three ultimatums on which I rely. And of course, I accept that if I show you those first, I'm not giving you the full context, but I'd like you to have those in mind. And then what I will do is go back to about a dozen emails quite quickly, which put them in context so you can see them fairly in the context of the negotiations that led to them. And in the course of doing that, I will have dealt with the first four of the propositions because I'll also deal with the timing and the background to salvage. So that will be the first 4 points. Then I will deal with the last three, and that is the shape of the appeal. So my lady and my lords, as far as the law is concerned, there wasn't really a dispute before the judge, and I don't think there's a dispute on the appeal. But the general principles are most helpfully set out in the authorities bundle at tab 7. In RTS, Flexible Systems, and Morchieri, Alios Muller, GmbH. This was a case where there had been letters of intent and the agreement was going to be subject to contract. And the issue that went to the Supreme Court is whether the performance of the work in effect amounted to a waiver of the subject to contract provision. But in the course of that, Lord Clark summarises the position. And if I could take you please to page 176 in the bundle, taking the numbers on the bottom right-hand side. The general principles, it's the bottom section, the general principles are not in doubt. Whether there is a binding contract between the parties, and if so, upon what terms, depends on what they have agreed. Depends not upon their subjective state of mind, but upon a consideration of what was communicated between them by words or conduct, and whether that leads objectively to a conclusion that they intended to create legal relations, and had agreed upon all the terms which they regarded or the law requires as essential to the formation of legally binding relations. Even in certain terms of economic or other significance to the parties have not been finalised, an objective appraisal of their words and conduct may lead to the conclusion that they did not intend agreement of such terms to be a precondition to a concluded and legally binding agreement. And then dropping down to paragraph 47, we agree with Mr. Catchpole's submission that in a case where a contract is being negotiated subject to contract and work begins before the formal contract is executed, it can't be said that there will always or even usually be a contract on the terms that are agreed subject to contract. That would be too simplistic and dogmatic an approach. The court should not impose binding contracts on the parties which they have not reached or will depend on the circumstances. And then at 49, Lord Clark quotes from the Court of Appeal in Pagnon, where Lord Justice Lloyd, with whom Lord Justices O'Connor and Stock agreed, summarised the relevant principles in this way. In order to determine whether a contract has been concluded in the course of correspondence, one must first look to the correspondence as a whole. Even if the parties have reached agreement on all of the term proposed contract, nevertheless they may intend that the contract shall not become binding until some further condition has been fulfilled. That's the ordinary subject to contract case. Alternatively, they may intend that the contract shall not become binding until some further term or terms have been agreed. Conversely, the parties may intend to be bound forthwith, even though there are further terms still to be agreed or some further formality to be fulfilled. If the parties fail to reach agreement on such further terms, the existing contract is not invalidated, unless the failure to reach agreement on such further terms renders the contract as a whole unworkable or void for uncertainty. It is sometimes said that the parties must agree on the essential terms and it is only matters of detail which can be left over. This may be misleading since the word essential in that context is ambiguous. If by essential one means a term without which the contract cannot be enforced, then the statement is true. The law cannot enforce an incomplete contract. If by essential one means a term which the parties have agreed to be essential for the formation of a binding contract, then the statement is tautologous. If by essential one means only a term which the court regards as important, as opposed to a term which the court regards as less important or a matter of detail, the statement is untrue. It's for the parties to decide whether they wish to be bound, and if so, by what terms, whether important or unimportant. It is the parties who are, in the memorable phrase coined by the judge, the masters of their contractual fate. Of course, the more important the term is, the less likely it is the parties will have left it for future decision. But there's no legal obstacle which stands in the way of the parties agreeing to be bound now while deferring important matters to be agreed later. It happens every day when parties enter into so-called heads of agreement. And the same principles apply here when one's considering whether contract was concluded in correspondence as well by oral communications and conduct. So it's an objective test, and the question is, did the parties intend for there to be a contract, a main terms contract, even though there was going to be further negotiation on further terms later? And that's a question of law. And I don't need to read it all to you, but in tab 12, you'll see we've marked up the relevant sections of Chitty, which are to the same effect. And the only one I just want to highlight is at page 322. Where 4158, yet a third possibility is that the main agreement lacks contractual force for want of execution of the formal document, but nevertheless a separate preliminary contract comes into existence at an earlier stage, for example, when one party begins to render services requested by the other, so that under this contract the former party will be entitled to a reasonable or agreed remuneration for those services. This may even take the form of a letter of intent, so as long as the words subject to contract are absent. And then in the judgment itself are two paragraphs which summarise the position. If one looks at the judgment, in the core bundle at 63, paragraph 35, the judge refers to Mr. Justice Parker in the von Hansfeld and Wildenberg case. It appears to be well settled by the authorities if the documents or letters relied on as constituting a contract contemplate the execution of a further contract between the parties. It's a question of construction, whether the execution of the further contract is a condition or term of the bargain, or whether it is a mere expression of the desire of the parties as to the manner in which the transaction already agreed in fact will go through. In the former case, there's no enforceable contract, either because the condition is unfulfilled or because the law does not recognise a contract to enter into a contract. In the latter case, there's a binding contract, and the reference to a more formal document may be ignored. The fact that the reference to the more formal document is in words which, according to the natural construction import a condition, is generally, if not invariably, conclusive against the reference being treated as the expression of a mere desire. And then at 36, the judge quotes a decision of my Lord Justice Mayles. In brief, it is well established that the whole course of the parties' negotiations must be considered, that it is possible for parties to conclude a binding contract, even though it is understood or agreed that a formal document follow, which may include terms which have not yet been agreed, and that whether this is what the parties intended must be determined by an objective appraisal of their words and conduct. And then the final authority I wanted to draw your attention to is an example of what was quoted in Chitty at 4158, which is the decision of Mr. Justice Clark, as he then was, in the authorities bundle, tab 1, the Kernia Dewi. This was a case where Smit International Singapore were awarded a wreck removal contract, but it required a permit before they could actually carry out the services. but they had been requested by the club to mobilise tugs. And although they couldn't carry out the service because of the lack of the permit, they claimed that there was a contract before that because they had been requested to mobilise the tugs, and they had done so. And they said on that basis there was a contract for them to be remunerated on a reasonable rate. And permission was given by Mr. Justice Mance, as he was, for permission to serve out of the jurisdiction. And then it came back to Mr. Justice Clark on a set-aside, and the issue was, is it seriously arguable? But it's just interesting to see how he analyses it. And I'm going to come back also possibly to a question of certainty later in the light of this case. So, if one goes to page 7, and in the right-hand column, you'll see the message, the facts that's referred to later in the judgment. And if one goes to the, you see the headline on the right-hand side, Kearney of Devon. If you go to that second paragraph, what the fact says is, as discussed, we would greatly appreciate you mobilising immediately. We confirm we shall finalise the wording of the formal wreck removal agreement earliest next week. And then if one goes to page 10 at the bottom, and if you take the top left, all depends upon the intention of the parties, which are to be derived objectively from the nature of the contract, its terms and the surrounding circumstances. And then if one jumps down to the next bit where we've marked aside, as I see the case at present, without of course expressing any view as to the likely outcome of a trial, the most convincing way in which the plaintiff's case could be put is along the following lines. The club, through their agent, intended the plaintiff to mobilise immediately on receipt of the facts, and to do so before either the permit was obtained or a formal contract was entered into. And then jumping down to the next sideline, on the face of the facts, the club were thus asking Smit to take a step before the issue of a permit, in circumstances in which a permit might not be issued, and in the absence of a formal agreement. They were given them formal instructions to do so, and on the basis that the club confirmed their full involvement. The club can surely not have intended that the plaintiff should mobilise without being paid if for some reason, other than perhaps in fault on the part of the plaintiffs, the permit was not granted and they could not proceed. In these circumstances, the club must have intended that in that event, however unlikely it must seem, the plaintiff would be paid reasonable remuneration for mobilising as requested. And then the next one we've highlighted, an intention on the part of the club that the plaintiffs would be paid reasonable remuneration in return for mobilising as requested is to be inferred from the terms of the facts having regard to the circumstances it was sent. The contract thus came into existence when the plaintiffs mobilised in response to the formal instructions of the facts, or perhaps when the fact of mobilisation was communicated to the third party. And then, just to finish this case off, one goes to page 15 at the bottom, which we've highlighted the last of the black bars. The interests of the parties and the ends of justice will best be served by concentrating on either settlement of or preparation for a trial on the merits. The court might not be too surprised with that hint that the case then settled. So the three critical ultimatum messages that we rely on, which we say at the heart of this appeal. And as I say, once I've shown you those, I will go back to put them in the context, but it's important to have them in the mind as we go through. And the first one of those can be found in bundle S1, tab 68. At page 136. And this is at 0746 UTC on the 26th of March. So three days after the grounding.
Sorry, tab again.
Yes, it's
68.
68. page 137. Smit has given ultimatum that if we do not agree to the main terms of the offer, they will start demobilisation. Please discuss with owners and give me the go-ahead to agree main terms of Smit's commercial offer. And our submission will be that it is what it says it is. It's an ultimatum, i.e. a final offer or demand by a party engaged in negotiations, the rejection of which will lead to a break in relations and unilateral action. It's an ultimatum, and it's an ultimatum for what? It's an ultimatum for an agreement on the main terms. So it's suggesting that there must be an agreement, and why is this being done? Because the tugs are being mobilised. Smit will be incurring substantial expenditure, and they need to have an agreement in place to protect them. So that's the first ultimatum. And so I will show it to you in the context of all of the things, but it's just worth having a look at.
This is actually a report of an ultimatum. This was what, given orally, or
Yes. So it was an oral discussion,
Yep.
and this is the report of the ultimatum.
Conversation between Captain Sen and
Yep.
who? Smith.
Mr. Shield. And at the Captain Sen, in his witness statement at the trial, Captain Sen gave evidence, simply refers effectively to this correspondence. He doesn't take it any further in his witness statement than saying this is what happened. So there's nothing more in there.
Does the judge make any? Sorry to interrupt. Does the judge make any findings about that conversation?
Well, if you look at his chronology, he effectively finds that that is what happened. In the chronology, he lists all of the different things, and this is in here. But he says no more than, this is what happened. He reports this.
There are no findings as to the content of that conversation beyond what's reflected here.
Correct. And there was no evidence beyond that. So as I say, Captain Shen, in an errata to his witness statement, said, I've looked at the documents, this is what happened. And Mr. Shield on the other side was not called. So one has got simply the document as to the content of the ultimatum. But
when you refer to the judge's chronology, you mean the appendix to the judgment?
yes, I do. And which he describes as findings of fact in his judgment. He says, appendix is my findings of fact. And then there's a very, very long appendix, which I call the chronology.
Yeah, okay.
The other thing to bear in mind when looking at this document is that one of the points that is made by my learned friends is that Smit were happy to proceed what they call on speculation. That would be that a salvor expends money in the hope that it will make money. This document suggests that they were not prepared to proceed on speculation because they're giving an ultimatum that unless there is an agreement on the main terms, they will demobilise. Demobilisation means not proceeding with the tugs, not proceeding with the personnel.
How does that square with the fact that they also seem to have been quite keen on a no cure, no pay agreement?
The difference, if you have an LOF, is of course you then have the right. You can't be dismissed by the owners, and you can actually turn up and say, I have been called by the owners to this salvage. So you're right that you could have speculation in those circumstances, but then you've got a binding contract where the owners can't dismiss you. It would be a breach of the LOF if they did that. And you can turn up to the SCA and say, I have now been appointed by the owners under LOF terms. So it gives you different rights. But what is being suggested in the respondents is that they were quite happy to speculate without any contract, LOF or commercial. And all I was pointing out is here, the ultimatum is that they will demobilise if there isn't an agreement on main terms. And what they're talking about is an agreement. They're not talking about, as the judge puts it, progress in negotiations. They're talking about an agreement. The second ultimatum, which again was obviously first oral, but again there's no further evidence or findings apart from the document, is to be found at S1 tab 74 of page 142. And we will come back to at 142. You can see this is now 0843 UTC. Thanks yours and duly noted and shall be ignored, which I'll come back to. As discussed, so there had been an oral discussion again, and this is now confirmed in the email. We need to have an agreement with owners by 12 o'clock Dutch time today. So that's 11 o'clock UTC. So it's, otherwise, we will have to take a firm position and stand down our operations to protect our interest. The tugs are on charter to Smit and are steaming full speed to the Ever Given. Awaiting yours soonest, we will revert formally by mail at 11 o'clock with all involved in CC as discussed. This message is quoted in the judgment, but only the first part of it. He doesn't quote the part about the tugs being on charter, or we will revert formally by 11 o'clock. He quotes the first part of this and deals with it in his judgment.
You may be coming back to this, but what's the subject matter of that last comment? Is that in relation to operational questions?
No, I will come back to, because I said I would put it in context. What seems to have been suggested is that Smits required a decision from owners as to whether to accept the commercial terms by 11, before 11, and then they would formally again set out those terms, which would then be subject to the agreement by 12. So it relates to formal offers that could be accepted. And I'll show you the context of that. The important things to note is the word formally. It is, we say, important. It's not just negotiations, it's formal. The time of the agreement is 12 Dutch time, which is 11 UTC, but 8 PM in Japan. Smit are looking for an agreement. We have to have an agreement by that time. If you read this with the previous message, that agreement must be relating to the main terms, because that's what they were asking for in the previous message. It can't be for the whole, all the terms of the wreck hire. And again, Smit would take a firm position and stand down.
Sorry, it's my fault. I have.
Yes, I'm sorry.
So what is going to be the subject matter of the mail at 11 o'clock if by that stage the ultimatum has expired?
No, the ultimatum. The ultimatum is.
Does that mean 11 o'clock Dutch time?
Yes. So, but when you look at all of the emails, you will see that what he was asking for was the. I'll show you in a second. The owners to confirm that they decided to go on commercial terms. Then was it didn't happen, but it looks as though there was then going to be a formal email setting out those terms again, and then there would be the agreement by noon.
If the tugs are already on charter, that suggests that Smit has committed themselves to some extent, but is the reader of this message supposed to infer that there's a right to cancel at
True position is that
deadline at 11, or
they weren't on charter.
well, that's neither here nor there. We're looking at the what objectively passes between the parties.
But between the parties, it was not on charter in such a way that they could not cancel. So you'll see that the position was there was no charter agreement at this stage, and ultimately parties knew that. But even if they didn't, a reasonable reader would assume from this that there was a right to cancel, because demobilisation in this context can only mean cancellation of the tugs and removal of the people. And if you're talking about protecting our interests, the economic interests here are the tugs. And you will see that when we go through it. You will see the references to we're about to engage the tugs. We must have your decision. So, in fact, they weren't on charter, and the parties probably did know that. But in any event, a reasonable reader reading this would assume that there was a right to cancel if it was. because that's the context.
Thank you.
And if that's right, of course, again, it suggests that Smit were not prepared to act on speculation because they needed the agreement by 11 UTC in order to protect their interests.
Sorry, it's my fault. The formal, what's going to be reverted formally by 11 o'clock, you say Dutch time, is the main terms, is it, not the ultimatum?
Correct. Perhaps the quickest way is to
So
show
don't
you.
worry, you're
No,
going to
no.
come back to it. I just want to make a note of what
If I
what
show
it
your
is.
lordship, if I show your lordship 147, which is the third and final ultimatum, it may make better sense. So the third one that we rely on is at S1 tab 79, page 147. And this is 1037 UTC, which of course is 1137 Dutch time. So if your lordship cross-refers back to 142, where it says we will revert formally by email at 1100, that's Dutch time. So by the time this email has been sent, it's 1137 Dutch time, i.e. after that deadline. And then, in my submission, it then makes sense if you read what it says, which is, please allow me to refer to the telephone conversation that you had with Jodie this morning, in which it's agreed that you will get back to us with a decision before 1100 hours, after which we would repeat our position in a formal message. And we would say, repeating the position in a formal message is what was being referred to at 142. And that must be on the main terms. With that time having elapsed, because this is now 1137 Dutch time, I checked with Jodie and understand you've just had a telcom with him, which is why I would like to repeat our offer as submitted last night and make it clear that your recap as sent below is incorrect and not on the table, as our offer of last night supersedes that. For the avoidance of doubt, specifically relating to the bonus arrangement, the percentage is 35% irrespective of the manner in which the vessel will be refloated. Alternatively, we remain open LOF terms. With the world watching us, and presently having our hands tied behind our backs, failing the requested confirmation of either a commercial agreement or LOF, we may be left with little choice as relayed by Jodie. Trust to have clarified sufficiently and look forward to your earliest confirmation. And the confirmation that he's asking for in that final sentence is the confirmation referred to in the penultimate paragraph, which is confirmation of either a commercial agreement or of LOF. LOF is a contract. And so what he's asking for is confirmation of a commercial agreement. That has to be done by 12 noon Dutch time, or they will have little choice as relayed by Jodie, and what the choice was to demobilise. So we say, reading those three ultimatums together, what Smit are asking for is an agreement by 12 noon Dutch time, and that agreement is a main terms agreement. Otherwise, why are their hands tied behind their backs? That must mean that they do not have any contract but are being expected to mobilise tugs and personnel. And that's why they seek a confirmation of either a commercial agreement or LOF. And confirmation there is a contractual agreement. And as we say in our submissions, written submissions, Smit was restating its intention to withdraw its services to demobilise in the absence of a contractual commitment. So those are the three messages. I've explained in opening shortly, and I'm very happy to develop that if you need the basis of salvage on no cure, no pay. And of course, that kind of common law salvage has problems for both the owners and the salvors. From the owner's perspective, you have no idea what the final sum will be that you will be paying. And from the salvor's perspective, they've got no guarantee of payment, which is why many contracts are on commercial terms. The owner knows how much it's in for. The salvor knows that it's going to get a certain amount for hiring tugs and for personnel. And one can also see in the salvage contract context why you would have or may have a main terms agreement with the detail later, because obviously if you've got a casualty where you want a salvor to respond urgently, you want to have the main terms so that he will mobilise in the same way as in the Lord Clerk's case. I want you to mobilise, I will pay, and we can agree the rest later. Because of course it may well take time, as in this case, for the tugs to be mobilised and arise on the casualty. So that's the commercial reason why you would have a main terms agreement with details later. The other point that I made on the timing when we look at all these, as I've said, is one has to bear in mind that noon Dutch time is 8 p.m. Japanese time, where you are dealing with Japanese insurers and Japanese owners. And where the judge says that it could be contemplated everything would be sorted out that day, we would say that's just unrealistic to expect lawyers in London to have got all of the wreck hire details sorted out when you've only agreed all this at 8 p.m. in Japan on a Friday.
And this is a huge casualty. The world is watching. It's potentially vastly expensive for owners and their insurers. Would it be unrealistic to expect people to work through the night?
Not necessarily, but it would equally be more realistic to expect people to agree the terms that they need to now, and then for the lawyers and the insurers to thrash it out in the coming days. Because that one has to weigh up, of course it's a big casualty, of course many people work through the night, but if you've agreed all the main terms that you need now, i.e. you've agreed the remuneration for the mobilisation, it is, given the time differences, quite reasonable to expect people not to do that. All I'm doing is challenging the judge's finding that it would automatically follow you'd expect it to be done between what is actually, when we look at it, 8:40 in the evening by the time people have finished talking to each other, and midnight. Equally, when you look at the reflotation, the next reflotation attempt is 1 hour, 20 minutes after this has all been, on our case, agreed. So it makes complete commercial sense, we submit, to agree your main terms. And then when you have lawyers in different time zones with the details to be dealt with not so quickly, which is, as we'll see, is what actually happens, that everything slows after this is agreed at 12 noon. So what I propose to do now is take you through about a dozen messages that led to the ultimatum, and then take you to the 5 or 6 messages which are the agreement, and then I'm almost finished. So if you have S1 available, most of the messages are in S1. And if we start, please, at tab 22 at page 39. This is the commercial proposal that is sent by Smits at 12:03 UTC on the 24th. Further to discussions earlier today regarding the commercial way forward, we herewith summarise the following daily hire arrangement. Contract Rec Hire 2010 logically filled and amended, and then sets out the contractors, sets out the scope of work, which is pretty standard salvage, assessment of salvage team, preparation and reflotation by pulling only. And then daily hire rates for contractors, personnel and equipment at Scopic 2020 rates, commencing from start mobilisation and completion of mobilisation including any waiting time delays due to COVID-19 procedures, quarantine, etc. All out of pockets, this includes external costs at documented cost plus 15% handling fee. For all out of pockets over and above $5,000, contractors will reasonably try to seek approval from company representative. And then dropping down, any other services such as cargo, lightning or dredging will not be included in the above proposal. In such a case, we would like to keep the option open to change the contract form to an LOF. So the main terms here are setting out, we're going to provide salvage services, setting out the rates. I jumped the list of the personnel and craft, but you can see that.
Scope.
I've said scope. Scope, I've said. Thank you.
Haven't read it.
The court can read to itself scope, which is assessment by salvage team, preparation for refloating, and refloating by pulling only. Then you have the daily hire rates, the out of pocket, the list of the personnel. Craft, we will revert with full overview of tugs options shortly, based on further insights on the manner and matter and internal assessment on board. A recommended a mutual decision can be made. Refloating bonus 25% on gross revenue of the total contract value. Payment, first 3 days upon signing agreement, thereafter regular invoicing every 5 days of hire of expected services in advance, final adjustment on completion of demobilisation. Any other services such as cargo, lightning or dredging will not be included in the above proposal. In such a case, we would like to keep the option open to change the contract form into an LOF. And lastly, by way of update regarding discussions with SCA, a meeting has been arranged by our liaison officer for tomorrow with our team arriving, OME team and Chief of Transport of SCA, who is coordinating the response from SCA side. So that is, as the judge found, an offer that could be accepted because it's those are the terms, and it's rec hire with logical amendments. So if this had been accepted, there'd be no question of it being subject to signing the rec hire, which rather suggests that the rec hire is a subsidiary to the main terms set out in this telex. Then if we go please to page 50, at 1630 UTC, you get an email explaining the mobilisation of personnel. We're pleased to confirm 5 Smit team have received negative PCR tests this afternoon and are now at the Amsterdam airport for departure to Cairo. Arrival at Cairo will be 02:40 tomorrow, 25th of March. Subsequently, the team will proceed to attend the meeting with SCA and also board the casualty as soon as possible. Advised before, the 7-person Nippon team coming from Japan is scheduled to arrive the 26th of March, with onward travel should arrive on board 26th or 27th. Tug options, please find enclosed Excel overview with tug options which we have sourced in the region. Also enclosed are the specification sheets of the most relevant tugs. This overview is a living document. Quotations are subject to availability and possibly even other options will become available in due course. Further assessment on site and discussion by SCA by our team is necessary to decide on which tugs to engage in the refloating pulling only operation. But for now, an operational recommendation would be to opt for the highest bollard pull possible, with tugs coming from the south side, Suez Red Sea. Therefore, in principle, the tug ALP Guard would be a very suitable option. However, note she is in principle steaming to the far east. Therefore, the longer we wait with confirming, the further she gets from the casualty. Possibly the ALP Guard can be combined with one OME tug, the Ocean Suneye, the tug Red Sea Brigand, and or the tug Carlo Magno. We hope we can further narrow down the options in the coming 24 hours and commence with chartering discussions with respective tug owners. And then the assessment of the casualty situation, as indicated by our previous message, our naval architects are continuing to run their calculations, but assessment on site is necessary for full refloating advice. Furthermore, as discussed, please also try and obtain the lines plans and the latest loading condition. And then attached at 51 and 52 and 53 are different rates. And because it's an Excel spreadsheet, you have to put them next to each other. So I'll just read out what they show. You get the daily hire rates. So for the Sea Brigand, which is the 5th one down, there is on page 52 a lump sum of 120,000 for 3 days, and then after 15,000 a day. And then for the Carlo Magno, which is the next one down, it's 25,000 a day. And then for the ALP Guard, which is the 7th one down, if you go to page 52, it's the one that's it's 118,000 per day, plus a reflotation bonus of 118, and then over the page, a demobilisation fee of 413. You can see she's an expensive tug. Then if we go to page 60, at 2242 UTC on the 24th, Captain Sen informs Smit, as a heads up, principals may consider engaging tug Red Brigand to assist in tomorrow morning's scheduled reflotation attempt at 0800 hours and any future attempts. We will revert if we get the go-ahead. Please alert Clarksons accordingly. And then at 65, at 06:56 UTC on the 25th of March, Captain Sen instructs Smit to engage the Red Sea Brigand. He says, please engage tug Red Sea Brigand if Jody confirms that SCA will allow the tug to participate in future refloating attempts. Please also update us if Smit Salvage team has safely arrived. When will Jody be meeting the SCA authorities? In the event, the Sea Brigand was not engaged by Smit because the SCA contracted her itself. But it's that message which leads to the message that is referred to in the judgment at page 66. And this is on 25th of March at 07:29. Thanks for below and our telcom just now, responding to the points discussed. And then it sets out, 1, our team has indeed safely arrived in Egypt and are currently near Suez and the casualty. Clearance has been received to go on site on board and they should arrive there in the next couple of hours. FCA meeting scheduled to take place on board. We have already instructed Clarksons to mobilise and start drafting the charter for the Red Sea Brigand so the tug can be prepared to mobilise to the casualty site soonest. Whether SCA will allow the Red Sea Brigand to participate in the operations depends on the outcome of the meeting. Jody will advise as soon as possible. As discussed, and again, there was no relevant oral evidence on this, as discussed, it's important that we receive your owner's formal response to our commercial proposal, which is the document at page 39 I showed you, sent yesterday. We need some kind of assurance before we can ramp up our mobilisation efforts and make out-of-pocket expenses. Trust you will understand. Also, the rec hire wording needs to be discussed and negotiated between the parties. I believe this is being prepared in the background by respective legal experts. Furthermore, we understand our partner Nippon Salvage that the owner has cancelled the mobilisation of the entire Nippon Salvage team for reasons unknown. Could you check and advise? We will revert with updates on the Red Sea Brigand Charter and outcome of the SCA meeting. So the 3 bullet points at the beginning set out the context for what was discussed. And what was discussed is that Smit need some kind of assurance before, first of all, they ramp up the mobilisation efforts, and secondly, before they make out-of-pocket expenses. And they wanted a formal response. The judge found that this meant just progress in commercial negotiations, but we would submit that that is belied by the use of the word formal. Why would a formal response be required if all Smit wanted to see was that progress was being made in commercial negotiations? And the word assurance there is we would submit a formal assurance, a binding commitment or promise. it's totally inconsistent with the idea that Smith were mobilising on a speculative basis, that they require some kind of assurance before they mobilise and make out-of-pocket expenses. So we would say that if you read this fairly, it's inconsistent with the idea that the judge has found, namely that all that they want is some progress in negotiations. What my learned friend says in his written submissions to the court at paragraph 43 is that reading this, all that was required was, quotes, a sufficiently clear perception of the landing zone of the negotiations so as to provide assurance that a binding contract was achievable. We say that is incorrect because it's not what the message says. It self-evidently would not provide Smiths with any assurance that they would be able to get their out-of-pocket expenses if the parties are simply negotiating and reach no contract.
So at this stage, you don't suggest there's any contract?
No.
At this stage, Smit have incurred some out-of-pocket expenses and they have made some mobilisation efforts.
But they haven't engaged the tugs.
So does one infer from that that they were prepared to incur some out-of-pocket expenses and to make some mobilisation efforts without any contract or assurance?
They were prepared to mobilise their personnel to the vessel. So yes, to that extent.
Well, and they'd be negotiating with clocks and something, or getting clocks and
yes, but they hadn't.
Tugs. They may not yet have concluded the charter party.
Correct. They haven't. And what we're saying in the context of this is that the large out-of-pocket expenses is going to be the tugs. That's where the big money is.
It's a question of degree rather than principle. They are prepared to incur some out-of-pocket expenses and make some mobilisation efforts without a contract, but you say not when it comes to the crunch of actually committing themselves to a large tug charter.
2 points. That's correct. Not when it comes to the crunch, but they're also saying they would then demobilise, which means that the personnel that they are sending, they would stand down or bring back. So there's 2 parts to it. But so they're not what they're saying is, yes, you're right, there's a limited amount, but what they're saying is for the big money, we're not prepared to do this without an assurance. And we will demobilise, we won't carry on the bit we have done without an assurance. And the question is, what does assurance mean in this context? An assurance is a promise you will be paid. The fact that you're negotiating provides you with no assurance whatsoever, because if you don't have a contract, you have no assurance. You flip it the other way around. If I want an assurance that I'm only going to be paying you X, the fact we negotiate and don't enter into a contract doesn't help me at all. It gives me no assurance whatsoever. So we say it's a stretch and wrong for the judge to say that what this means is simply we want to see some negotiations. Why a formal response? Why an assurance? But there's no contract at this stage. It's part of the context of the ultimatums. The other point to bear in mind is the use of the word also, i.e. we want the assurance, but then also, which is separate, and we'd say in the background, the rec hire wording needs to be discussed and negotiated. Now, at this stage, there isn't the only rec hire, there's no rec hire draft that's been provided. There's only been the reference at page 39 to rec hire with logical amendments. So there is no wording on the table at this stage. And we would submit that actually what they're focusing on is agreeing the main terms, and that the rec hire can be sorted out in the background by the lawyers. And then at page 69, you can see that the wording is then sent to Stan Marine, who are the owner's solicitors, at 07:45 on the 25th, hereward forwarding you the commercial salvage proposal, wherever given as provided yesterday to Webster's, which is page 39. And then at page 70, owners come back to Smith's at 0808 UTC on the 25th. I've just checked, reportedly the tug has been engaged by S.A, that's the Red Brigand. So no need Smit Clarksons to engage this tug.
Sorry, which page are we on?
So page 70, my lord. I've just checked, reportedly the tug has been engaged by S.A, so no need for Smit Clarksons to engage this tug. Instructions from Japan regarding your formal offer is below. Smit personnel to attend on site, discuss situation and operation with SCA. Smit to send a report on prospect plan, etc. ASAP after the meeting. Decision on reflotation, bonus, etc. will only be taken after receipt of this report during owner's casualty meeting at 0900 hours tomorrow. No proposal of AF will be acceptable at present. So what's being said at this stage is we need a report from your team as to what's happening at the casualty, and we can't make a decision on commercial terms until after we've seen that report, and that will take place during owner's casualty meeting at 0900 hours on the 26th, Japan time. That would be.
But nevertheless, in the meantime, they want Smit to be continuing to provide those services that are identified in this.
Correct. Correct.
0900 hours tomorrow, as you say, is Japan time, do you?
Yes. Yes, yes. Sorry. Yeah, Mr. Jacobs makes a very valid point. To go back to, my lord, one of the points you made about, which is also something that comes between the parties. If there are people on board when she reflates, then they would get paid under no cure, no pay. So if you send personnel on board and they are taking part in the salvage services, they would get, as soon as she reflates, they would get paid no cure, no pay. If the tugs are engaged and they are steaming to the casualty and she refloats before they arrive, they will not get the money for those.
Does this envisage the Smit personnel being on board or simply attending to assess and report?
Smit personnel to attend on site. The site is the casualty. And did they arrive on the 25th of March? We showed you that in the previous email.
They do in fact go on board.
Yes.
Yes. To undertake the assessment.
Yes. And because the whole basis is they go on board, they'll undertake the assessment, then they're going to report back, which will then be considered by the owners at the meeting at 0900 in Japan time.
And they also had people working in the office.
Then if we go please to page 83. This is the offer on the evening of the 25th of March that we saw referred to in some of the ultimatums. So 25th of March, 2140 UTC. So the evening of the 25th, early morning on the 26th in Japan. Captain Sen has promised, and in order to move forward with this matter, we herewith provide you with the following: commercial proposal, wreck hire draft, 2 separate documents, main body and additional clauses, salvage plan draft, operational illustrations as appendix to the salvage plan. We trust this is well received and look forward to discussing further with you. And B, regarding the proposed powerful tug, ALP Guard, we reiterate that she is currently slow steaming drifting in the Red Sea and in principle heading east. However, this valuable asset can still be made available for the operations if a decision, which I'd ask you to underline, is made tomorrow, 26th before or around noon. So again, they're not prepared to engage the APL Guard on speculation, but they can engage her, and at the moment she's going in the wrong direction, if, quotes, a decision is made by owners on the 26th before noon.
I think we saw from the previous commercial proposal coming from Smith's that in relation to external tugs, that itself was to be subject to ad hoc agreement. So decision here may just be in relation to that tug as opposed to decision more generally on terms.
Well, if you look at the context of this, we would submit, and then the ultimatums, it's a decision, and it's the timing is the noon on the 26th. That's why I highlight these two.
It's a decision about this tug.
No, it's a decision about these terms we would submit. Because if you look at page 86, the last paragraph, I'm going to go back through the terms, and I know my friend would want me to anyway. Given the extremely pressing nature of the matter, in view of the hourly increasing traffic jam of vessels awaiting their passage through the canal, the impact on their schedules and international trade, we would sincerely appreciate receiving your earliest decision so that we can immediately put our drafted plans into action. The necessary preparations are done and we are ready to spring into action. So that decision is, we would submit the decision on the commercial terms, not on the decision on a particular tug, but on the whole terms. Because that's why they're saying we can spring into action, but they're not going to spring into action unless a decision is made. And the decision must be to accept these terms. And the time that that has to be done is by 12 noon on the 26th. So we submit that the decision that Smit is looking for is a contractual agreement relating to these proposals. And we would also submit that reading this fairly, they were not going to be engaging the AL guide unless there is a decision on, if it goes back to 83, the commercial proposal. And then they set out.
So if we go back to 83, it's not just the commercial proposal, it's also the red card draft.
It's the commercial proposal, the red card draft, the salvage plan draft, and the operational illustrations.
So if there's a decision by way of agreement on all of it, then there's a contract.
Of course there is, and of course there is.
I'm not quite sure what else you get out of decision.
That there has to be a contract. And the
At
question,
this stage, what's envisaged is everything.
correct, but that's why I said that you have to look at the ultimatums in context, because here you've got a decision on everything, but they want a decision. And then when we look at the ultimatums, what they want is a decision on the main terms, not on the whole contract. That's what changes between the evening of the 25th and the morning of the 26th. And you can see how it's structured. And it's quite important. So, my only point that I was making on this is that the word decision means a contract. There's then a debate about what the contract is. And your lordship is right. What is on the table is all of it. On the 26th, it's clear that what they're asking for is the main terms of it. We need to look at it to see what the main terms are. And you start with commercial terms and conditions on daily hire basis. The initial brief commercial proposal was already provided to you yesterday. That was 39.
Sorry, where are you reading from now?
I'm sorry, on page 84, halfway down, commercial terms and conditions on daily hire. With initial brief commercial proposal was already provided to you yesterday. That's page 39 that we looked at. And following on with discussion, we can summarise the main terms and conditions as follows. Contract, rec hire, logically filled in and amended. For your review, please see enclosed the proposed draft wording of the contract stating all relevant contracting details. Contractor, Smit Salvage. Nature of services, assessment of vessel condition, preparation of the vessel for refloating by shifting or discharging ballast, water and fuel, coordination and liaising with SCA arranged tugs and contractors tugs, cargo lights and angles, dredging if required, delivery of the vessel, liaising with and operating with the relevant authorities including SCA. Over the page, contractors craft, equipment and personnel at Scopic 2020 rates with no uplift commencing from start mobilisation until completion of demobilisation, including any waiting time delays due to COVID-19 procedures, quarantine, etc. Third-party craft, equipment and personnel at cost plus 15% uplift. refloating bonus 35% of the sums due in the final agreed running cost sheet. Payment first 3 days on signing of this agreement, thereafter in advance every 7 days for subsequent invoices based on the running costs. And then there's the operational transition to the Lloyd's Open form. Due to the complexities, we reiterate our recommendation to perform the services based on LOF. However, we respect the wish of the vessel's interest to commence the service on a daily hire basis, which is evidenced by our above proposal. Nevertheless, should owners' vessel interest be desirous of changing the contract to add LOF, we should be open to consider this. And then they then detail the support and coordination and the operational scenarios, which they list from 85 to 86, which the court can read. And then at 86, penultimate paragraph, the above steps, including further detailed planning, description of methodologies and illustrations, are further described in the preliminary salvage plan, which is enclosed herewith. Given the extremely pressing nature of the matter in view of the hourly increasing traffic jam of vessels awaiting their passage through the canal, the impact on their schedules and internal trade, we would sincerely appreciate receiving your earliest decision so we can immediately put our drafted plans into action. The necessary preparations are done and ready to spring into action. And then attached to it, you can...
Sorry, just before we go there, page 84 describes the wreck hire working as one of the main terms and conditions.
Yes, at this stage.
So at this stage, it's the case that that is one of the main terms that needs to be agreed, so far as one can discern the position objectively from this communication.
Well, objectively, you would have to agree it was on rec hire terms. Yes. Yeah. But the point is that it's not considered to be a problem to agree this. If you remember, if you go back to the ultimatum, what was envisaged is once you've agreed the main terms and you agree it's going to be on rec hire, the solicitors can then deal with it. So that was what was being said in the assurance email just before this one. So
Well, it cuts both ways slightly, doesn't it?
it does. I agree with that.
If everybody thought that actually there wouldn't be any problem agreeing the rec hire terms, then that's consistent with them thinking that those were necessary, but it wouldn't be a problem.
But it works both ways, because it can easily work the other way, which is that once you've agreed the main terms, everyone was going to do it on rec hire, and therefore it wasn't subject to agreeing that, because it would just follow. So it would work both ways. In my submission, is neutral. But you need to read this with the previous email, the assurance email, where what is being contemplated is that the parties would agree the main terms, and then once that was done, also in the background, the lawyers could then sort out the rec hire, because you'd agree the logical amendments. But what actually happens is if you look at this document, you've got attached to it a number of pages, 87, 88 are line drawings, then you have the draft salvage plan at 89, which goes on to 99. Then you have at 100 2 pages of what are described as additional clauses to rec hire. Now these are not logical amendments to the main terms, they are additional clauses, and therefore would require some negotiation between the lawyers. This is not even though the main terms had said it's a logical amendment, when one looks at page 100 and 101, these are actually additional terms. And 102. And then you have the rec hire itself at 103. Part 1 goes to 105, and then part 2, 106. To 117 is the rec hire, and you can see that there are amendments to this that are additional clauses or deletions, which are not, again, simply logical amendments. They are actually deletions of the delay clauses. There are alterations in the bonus, reduced rates, and so on.
And quite important terms like scope of work,
Yeah.
when payments are to be made, those sorts of things.
Exactly, yeah. And we submit that therefore you can't have anticipated actually that all of that would be agreed in a very short period of time. As soon as you start amending the rec hire and adding clauses and changing things and you get lawyers involved, there may well be a delay. And the judge finds that 60 and paragraph 60 and 62 that Smit would have expected to receive something very early the following morning on the 26th, their time. And we say, how could that sensibly, I know you're going to say you can work through the night, but actually, if you've given a document this long in Japan at 7 in the morning, and everyone in England is asleep, it is going to take quite a bit of time toing and froing to go through this plan and the amendments to the rec hire and the new clauses. It's not quite as straightforward as logical amendments now.
Well, the suggestion is that it's going to be an English law contract.
Yes.
So you'd expect the Japanese to have some English lawyers on board.
Which are at Stan Marine, who are in London, 9 hours behind them, and are asleep when if you have the meeting in Japan at 9 a.m. in the morning on the 26th, the operational, it's going to be midnight. So you're gonna have a delay in discussions. And then on 121. Captain says, we acknowledge receipt of your email and documents. As a heads up, we may engage ALP Guard once we have the green light from owners. We will also revert on your proposed commercial offer as soon as possible. Which is, so that's 22:28 on the evening of the 25th. Then at 122 on the evening 22:37 on the 25th, Smit S.A. also bring the Carlo Magno to the attention of owners in combination with ALP Guard as recommended. We will speak tomorrow. And then you get at 127, Captain Sen saying, please proceed with engaging ALP Guard immediately in order for tug to proceed to casualty site. Owners of Carlo Magno can be advised that vessel will be fixed by you once tug arrives at Suez and casualty is still aground. We understand the vessel is about 2 days away from Suez and is en route to Suez. So that's at 03:39 in the morning.
Reverting on offer shortly.
Reverting on offer shortly. And 128, thanks for your message below and telephone just now. We will follow up with the 2 tugs accordingly. We'll let you know once fixed and mobilising to site, including ETA. And then at 133, at 06:06 on the 26th, Smit send the commercial proposal, the salvage plan, the rec hire wording to the English lawyers at 06:06 on the 26th.
Owners English lawyers.
To owners, what did I say?
You just said to English lawyers. It's to owners English lawyers.
To Stan Marine, who are owners English lawyers. Thank you. And that is then the context for the first of the ultimatums. Because if you then go to 136, you can see that after they've sent the proposal from last night, at 07:46 is the reference to the ultimatum that if we do not agree to the main terms of the offer, they will start demobilisation. So they've sent an offer which is detailed, and they have now sent an offer that unless you agree to the main terms, you will start demobilisation. And then it's a question of what the main terms is going to be. But I would respectfully submit that in the light of that context of looking through, the ultimatum is about an agreement. Not about negotiations, it's about an agreement. You're asking us to fix two big tugs. You want us to mobilise. You've asked for a decision. We now give you an ultimatum. You must agree to the main terms of our offer.
So, in terms of what's meant by main terms at that stage, is it as yet undefined, or is it main terms as they've previously been identified at page 83?
Its main terms, well, it's undefined in this message, but it's on the basis of the offer that was made previously. And you will see what the main terms are when you see what is agreed and not agreed.
Yeah, but just pausing at this stage,
Yes.
we've seen 83 and 84 identification of what the main commercial terms are.
Yes.
You say in this ultimatum, it's not referring to those as the main terms, it's referring to the main terms in general, and they're going to identify what those are in the future.
Well, you see, you only have this document. You have no evidence of what they discussed and what they meant. So objectively, what I will submit, and when you look at what they then pass between each other, the main terms is the remuneration.
I can understand you're going to come on to what it is, but just at this stage,
Is the remuneration.
it's main terms to be defined, as it were, to be identified, rather than main terms as we've already identified.
Well, it's main terms to be identified, but as you will see, the main terms that are actually identified are ones at the top of page 85. It's the rates.
But at this stage, this was not an offer, was it, which was capable of being accepted so as to give rise to a binding agreement at this stage, because the main terms had not been sufficiently identified.
Well, there's two parts to that. There is an offer on the table that could be accepted, namely 84-85, but there is, your lordship is right that there is not an offer that could be accepted by identifying which of those are the main terms. Your lordship is right.
I mean, they could accept the whole lot,
Yes.
but that wouldn't be a main terms agreement. That
No.
would be an everything agreement.
Right. And so what is being said here is you must agree the main terms, but they have not been identified in an email as to what the main terms are. And it comes back, I would submit, to the question my Lord Justice Popplewell asked early on about what is being talked about as the formal document that was going to be produced at 1100 Dutch time. And in my submission, what was contemplated, which we'll see in a moment, is that they were going to set out and identify which ones of the document at 84 and 85 were the main terms. That is what you will see. You will see that they are going to offer and accept the remuneration package within this document, and that those are the main terms they're talking about. And if one pauses and thinks about it from the position of an objective person, at this stage, what Smit need is to know that they will be remunerated at an agreed rate. Rather like in the Lord Clark case, once you mobilise, you want to know that you will be paid. And what the main terms come to mean are the remuneration package, as we'll see. But all that is saying here is that there is an ultimatum that needs to be an agreement, and there needs to be an agreement on main terms.
To be identified.
Up the line,
Yes,
don't you?
ma'am.
This will be preceded by this what he's seeking to agree
Yes,
with the Japanese. I know it hasn't cost a lot, but that's all the secret. He was seeking instructions from him as to what he understood the main terms to be.
I'm so sorry. If you just bear with me
Not
one
at all.
second.
That's-
So page 129 and 136.
The what I've tried to do is show you just the emails that crossed the line. But of course, one of the problems is that there were discussions and reports back, and it's not always easy to tell whether those things were all discussed or not. But if one looks, but just to answer your Lordship's questions, but both your Lordship's questions as to what is in play about the main terms at this stage, if one goes to 129, you have to bear in mind that 136, as my Lord Justice Miles pointed out, is a report of a discussion. And 129 is an internal document which says, "Thank you for your email. I have instructed Smit accordingly as my below instructions. Please proceed with engaging LPA guard immediately in order for tug to proceed to casualty site. Owners of the Carlo Magno can be advised the vessel will be fixed by you once tug arrives at Suez and casualty is still aground. We understand the vessel is about 2 days away from Suez and is en route to Suez. I've also called Smit person so they can action immediately. Regarding commercial offer, we need to advise Smit that in principle owners agree with the following." And then he sets out Smit personnel and equipment to be paid on scopic rates, any hired personnel and equipment out-of-pocket expenses to be paid on scopic rate plus 15% uplift, refloatation bonus, 25% of gross invoice value to be increased to 35% if containers need to be offloaded to lighten the vessel for refloatation. In short, we're making a counter-offer to their current offer of 35% success bonus, irrespective of how the vessel refloats. The remaining contract clauses can be mutually discussed before parties final signature. Please advise urgently. Smit need to give some reassurance that owners have agreed to the points mentioned in A, B, and C above. And it's those A, B, and C that, as we go through, become referred to as the main terms.
I think Mr. Jacobs' point is probably that this 129 preceded
Yes.
the 136, but they were both after the call,
Correct.
or at least after two calls.
Correct.
And
And
at
so
least,
the
at least one of which there had been identified what it was that Smit were looking for
yes,
as the subject matter of the main terms,
yes,
and that you would have to read 136 in the light of that.
yes, that's correct.
Therefore, main terms recording the conversation that preceded 136 had already been the subject matter of oral discussion. It is to be inferred from 129.
Yes,
Is that the point you're making?
that's the point that Mr. Jacobs was trying to make, and I made very badly.
He's nodding anyway.
Yes, he agrees with your Lordship. So, well, thank you to Mr. Jacobs and your Lordship. The point is the main terms there is focusing on the remuneration. And then you see that based on that ultimatum, at 0816, owners send a message to Smiths in the following lines. Dear Jody Dave, so this is now 0816 UTC on the 26th. We are pleased to confirm the below on behalf of owners have ever given. Owners agree to the following: the tugs, dredgers, equipment engaged by S.A. and their subsequent salvage claim are separate to the Smith's offer of assistance. Smit personnel and equipment to be paid on scopic 2020 rates. Any hire personnel and equipment out-of-pocket expenses of Smit to be paid on scopic 2020 rates, plus 15% uplift. Refloatation bonus 25% of gross invoice value to be increased to 35% if containers need to be offloaded to lighten the vessel for refloatation. We look forward to your confirmation acceptance to the above. We can then start ironing out the rec hire draft. So we submit that this is an offer to agree to the main terms. It uses the word agree. It identifies the main terms, which are the same ones that we just looked at in the previous emails. And it looks forward to a confirmation and acceptance of that. And then you could start ironing out the rec hire.
Are they the same terms? I'm not sure they are.
No, that's why I say it's an offer, but based on the same points. It's the same terms as
Same as 129.
Same as 129.
Well, that's 129 is the internal.
Yeah.
What we're going to offer.
Yes, and this is
In
what they're
terms of, and this is what comes forward. But in terms of what had been offered by Smit, these are different.
That's a counter
Correct.
proposal.
It's a counter proposal. That's what he says at 129.
Yes.
But the point is that it is on.
I misunderstood. I thought you were saying
No.
these are the main terms that Smit is
it-
suggesting.
it-
My mistake.
No.
I misunderstood.
But the point I'm going to make as we go through is you will see it's talking about confirmation and agreeing and asking for confirmation and acceptance, which are contractual words of offer and acceptance. That's the point I make on these as we go through. And then at 140, you see that Captain Sen cancels that offer. Below email stands cancelled for now. Please give me a few hours to revert. There's been some confusion. If you want to cross-reference to the appendix to the judgment at A80, the judge explains that what happened was internally, Captain Sen was being asked to confirm what the offer was. He wasn't being given authority to do so. So he cancels this and goes back. It was just a mistake. So I say, if you cross-reference to paragraph A80 in the judgment, you can see that this is cancelled as a result of an internal cross wire.
I don't know, maybe you did.
I did do 139. Yeah.
No.
To it now. No, you didn't.
Well, 139 is the
That's
confirming the offer.
818. We've only done 816.
Oh, I'm sorry. So you get confirmation on that's the confirmation email, and then you get that cancelled at 140 because of the internal
Yep.
confusion. And then that leaves
139 is just 138, but with the Smit saying the bonus is 35% straight.
that's correct. He's going back to that's not the offer on the table from us. And then
And,
that
and presumably that the cancellation email came through before they got a chance to send that on to Captain Sen.
yes, you will see quite a lot of cross wires at this stage, people missing each other. And so then one goes to 142. Which is the second ultimatum. Thanks, yours duly noted and shall be ignored is confirming that it's cancelled. As discussed, we need to have an agreement with owners by 12 o'clock Dutch time today. Otherwise, we will have to take a firm position and stand down our operations to protect our interest. So what has happened is there's been the ultimatum that we need to agree main terms. Captain Sen sends a counter-offer to agree main terms. Smit says that's not good enough. He cancels it. And then there's a message which says we need to have an agreement with owners by 12 Dutch time today. That means a contract. And the only contract that it can be is the main terms that have just been discussed. Otherwise, we'll have to take a firm position and stand down our operations to protect our interest. The tugs are on charter to Smit and steaming full speed to the Ever Given, awaiting your soonest reply. We will revert formally by email at 11 with all involved in CC as discussed, which I would submit is then recounting the main terms by 11 o'clock. Then if we go to 146, this is now, we are pleased to confirm that below on behalf of the owners of the Ever Given, owners agree to the following. The tugs, dredgers, equipment engaged by S.A and their subsequent salvage claim are separate to Smit's offer of assistance. Smit personnel and equipment to be paid on Scopic 2020 rate. Any hired personnel and equipment out-of-pocket expenses of Smit to be paid on Scopic 2020 rate plus 15% uplift. Refloatation bonus 25% of gross invoice value to be increased to 35% containers need to be offloaded to lighten the vessel for reflotation. Reflotation bonus to Smit will be applicable if reflotation attempt by SCA on the 26th is unsuccessful. We look forward to your confirmation acceptance to the above. We can then start ironing out the rec draft hire so same can be signed at the earliest. So we submit that this is an offer, what he thinks is agreeing to the terms. You'll see there's a slight twist of the main terms, which are the remuneration, and that any claim for salvage would be on that basis. And then that leads to the third ultimatum. Because this came
Well,
to,
these are slightly different terms. You said he thought he was agreeing to the Smit terms.
they're slightly different, and you'll see why they're slightly different, and he comes straight back and agrees to them.
I mean, this, if I've understood, reverts to the terms which had previously been cancelled, but adds the final sentence about the reflotation bonus.
Correct.
That's, yeah.
But the problem that they were cancelled before was that he hadn't been authorised by internally,
And by now he has been.
but now he has been.
Extra sentence.
Yes. So 147, please allow me to refer to the telephone conversation you had with Jodie this morning, in which it was agreed that you would get back to us with a decision before 1100 hours, after which we would then repeat our position in a formal message. So the decision must be the decision on the main terms, and the formal message must be a recap of those. With that time having elapsed, I checked with Jodie and understand you've had a telcon with him, which is why I would like to repeat our offer as submitted last night and make it clear that your recap as sent below is incorrect and not on the table, as our offer of last night supersedes that. With the avoidance of doubt specifically relating to the bonus arrangement, the percentage is 35%, irrespective of the manner in which the agreement will be refloated. Alternatively, we remain open LOF terms. With the world watching us and presently having our hands tied behind our backs, failing the requested confirmation of either a commercial agreement or LOF, we may be left with little choice as relayed by Jodie. And in my submission, what he's saying is, we want an agreement on main terms, and that has to be either a commercial agreement on main terms or an LOF contract. And it's in the background of the deadline of 12 noon.
Well, the repetition of the offer as submitted last night is not limited to main terms, is it? Because the last night offer, I thought, was the whole thing.
What he's talking about, though, you'll see, is if you go back to that offer, he's not talking about the whole offer. He's talking about the remuneration part of it. Because what he's talking about here is, he doesn't come back and say, you cannot agree to these main terms, you must agree to the whole thing. He's saying the offer you have put forward at 146 does not confirm, it does not agree with our offer. If you keep your finger in 146 and go back to 85, you can see that the refloating bonus says 35% of the sums due in the final agreed running cost sheet. And then 146 in C has a reflotation bonus of 25% of the gross invoice value to be increased to 35% if containers need to be offloaded to lighten the vessel for reflotation. So that when you then go to 147, and he's talking about repeating the offer of last night, he's not talking about the whole lot. He's talking about the reflotation bonus. And you can see that that's what he's saying, because I would like to repeat our offer as submitted last night and make it clear that your recap as sent below is incorrect and not on the table, as our offer of last night supersedes that. For the avoidance of doubt specifically relating to the bonus arrangement, the percentage is 35% in respect of the manner in which the vessel will be refloated. So, trust to have clarified sufficiently, and we look forward to your earliest confirmation. He's not saying, I cannot accept your offer of main terms because I'm repeating the full offer we made last night. What he's talking about is, I can't accept your offer on May terms because what you're offering in respect to the reflotation bonus is different to what we have asked for. And that's all that means. And you can see that. Because if you go to 148, Dear Captain, thank you for your call just now, and our message is just crossed. And indeed, which is why the confirmation below is appreciated, yet not entirely correct, particularly relating to item C, the bonus arrangement. Our revised offer of last night clearly states 35%, irrespective of the manner in which the vessel will be reflated. If you ship's interest could revisit that in reconfirmation, please then we should be much obliged. So he doesn't go back and say, we need to agree to everything. He's focusing on the reflotation bonus. And then 149, we refer to our telephone conversation subsequent to my previous email, and my further conversation with Japan. As agreed over the phone, I am pleased to confirm as below on behalf of owners of Ever Given. Owners agree to the following. The tugs, dredgers, equipment engaged by SCA and the subsequent salvage claim are separate to Smith's offer of assistance. A, Smith's personnel and equipment to be paid on Scopic 2020 rates. B, any hired personnel and equipment out-of-pocket expenses of Smith to be paid on Scopic 2020 rates plus 15% uplift.
It's the same as 146, but with the 35%.
Correct. So what has happened
And with the new C1.
with the C1 and C, it's broken down, yes, C1
Yeah, sorry.
and C2. But the actual percentage, as Smith's asked for on the night before, and as they were called up on. So the owners have made an offer on the main terms. The Smiths came back and said, we don't agree with the reflotation bonus because it should be 35%, as we said last night. Owners then come back and say, agree, and then they set it all out, including the 35%, but they add in, so that would be a counter offer, C1 and C2. We look forward to your confirmation. We can then start ironing out the rec hire draft, so the same can be sent at the earliest. And again, if you...
C2 is not new, is it? It's C1. But
C1 is the new one. And if you go again to 84, where you've got nature of services, we say that in shorthand is effectively covered by tugs, dredges, equipment engaged, separate to offers of assistance, and then listing them. And then if you go over the page, you can see that the first bullet point is the contractor's craft, equipment and personnel at Scopic 2020 rates.
So what page are you on?
I'm comparing 85 with 149.
Thank you.
So you've got contractors, craft, equipment, personnel at Scopic rates, plus no uplift commencing with start mobilisation and to completion of demobilisation. It deals with hired personnel and equipment, which would cover the craft, and is whereas originally they asked for cost plus 15%, they're giving Scopic rates plus 15%, which is at this stage greater. And there's an internal email where Smiths comment on how foolish the owners are. They describe them as donkeys. And that's because of this change in the rate is higher. And then you have the reflotation bonus is dealt with. And what is missing is the precise payment terms, but that would be within a reasonable time. There wouldn't be a difficulty. So the main terms are covering all of these things.
Well, not nature of services.
Well, in my submission, it's shorthand. If you say tugs, dredgers and equipment engaged by SCA, it does cover, it's covering what you're envisaging doing. as a shorthand.
Well, can I just ask you that? Does any in B mean any that Smit choose to provide?
Yes.
So if, for example, Smit had decided we could have 10 tugs on standby, all steaming furiously towards the canal, then the owners would have had to pay for that.
But that's not what was.
No, but is that the effect of this contract?
Yes, but in the real world, people, as you've seen, the owners and Smit have discussions because professional salvors don't just get 20 tugs or something. They have a discussion about what's needed. Smit have already identified what they need is 2 tugs.
Well, because the earlier terms had specifically been that if external tugs were to be employed, that would have to be discussed and agreed specifically with the owners. But that's no part of this agreement, is it?
No, but it's against the background that what the parties have contemplated is 2 tugs, the APL and one other, which Smit have said they have engaged.
Well, this is the 26th of March. No one. There's only a draft salvage plan. It's all got to be agreed with the canal authority.
Yes.
The scope of services is uncertain. But I think your case is it's sufficient for there to be a contract, and there was a contract on the basis that the services which were to be remunerated at these rates were whatever services Smit chose in their own discretion to supply.
Correct. But against the background that everyone envisaged that there would be a further contract, so that it's like the cases that I showed you previously. You can have a main terms with people envisaging there will be a further, more detailed contract, but that doesn't mean that the first contract is not binding. And that's what was anticipated here. They've agreed the main terms, which is what the ultimatum was. So Smit will be remunerated, and everyone anticipated there would be a further, more detailed contract.
So if there is no further contract, are there terms to be implied that Smit must act reasonably in deciding which tugs to engage or anything of that nature?
Well, there might be. I mean, there might be an argument about that, but it may not be. What is being envisaged at this stage is we will pay you for the work you're doing. There might be an argument about whether you'd employ a term in these circumstances, but it's exactly the same. But the reason why I showed you the Clark case is it's very similar to the Clark case. We want you to engage and we want you to mobilise. We agree that if you do that and you provide services, you will be paid on this basis. It's exactly what happened in Lord Clark's case, where they were asked to mobilise and he implied a reasonable rate, and here they've actually agreed the rates. It wasn't suggested that that contract couldn't come into being because there weren't sufficient terms as to reasonableness and so on. The point was, I've asked you to mobilise. If you do so, either it's on an agreed rate or a reasonable rate. Now here, what they've said is we must agree by 12 million the rates, and these are the rates. And it's a main terms agreement. Now it's obviously contemplated that there will be a more detailed contract. And most people would probably anticipate in due course there would be. But if there isn't, it doesn't affect the validity of the earlier contract. So, but one of the points that is made in my only friend skeleton is this is almost insufficient because it's very limited. But the point is it mirrors the commercial the remuneration that Smit was asking for. And the judge has found, and there's no respondent's notice, that on its face it isn't sufficient to be a contract and the only issue is commercial intention. And Smit, if you look at these ultimatums and what is being said here, there was an ultimatum and words of agreement and acceptance. Because you then go to 150. Where Smith's come back and say thank you and confirmed which is very much appreciated. We'll inform our teams accordingly, and we shall follow up with the drafting of the contract upon receipt of your client's feedback to our drafters last night. So there's been wording of offer and acceptance and confirmation, and that is a contract. And you can see this is now 8:40 Japanese time. So again, it can't really have been contemplated that anything more than this was going to be agreed on the 26th. There really isn't time to agree any more detail on the 26th, which is why you have this contract. The next point we make is that the reflotation bonus in C2 can only work if this is a binding agreement by 12 o'clock, because the attempt of reflotation is 3 o'clock Egypt time or 1 o'clock UTC.
So have you now moved on from your dealing with the exchanges to
Yes.
point number 5?
Yes. Is there anything else you wanted to ask me on the
No, I just
exchange?
wanted to understand where you were in the whole scheme.
So I was then going to deal with the reflotation bonus. And the judge deals with this in paragraph 77 of his judgment. Where he says, the agreed stipulation the reflotation bonus would not be payable if SCA achieved reflotation on the 26th made no sense, unless the parties intended to be bound there and then. I disagree.
Sorry to interrupt you. Can I just ask you something that's going through my mind? If you have a house purchase, typical case of subject to contract negotiations, and the seller is being reticent, and the buyer says, I've made you an offer of £500,000, and I need to know whether I'm going to go to the expense of getting a surveyor in and so on. And we really must agree the main terms, which are how much I'll pay, and then it'll be exchanged on such and such a date, completion by such and such a date, and the usual terms, 10% on exchange. But unless we can agree those by 9 o'clock tomorrow morning, I'm going to walk away and go and try and find another house. And there's that ultimatum given, and the seller says, yes, that's all agreed. Is that still subject to contract or not?
Yes, because of course because context is everything.
And why is this?
Because there's nowhere. This one is different because there's nowhere, as it said, subject to contract. One of the points that was debated in front of the judge is if you're going to do that, and of course everyone knows house purchases are subject to contract. If they had said that, then of course the context of these communications would be different.
But does that depend upon an analysis of what the position was prior to discussion of main agreement terms or the ultimatum? Suppose it were the case, and you may not accept this, but suppose it was the case that at least at the stage where page 83 was what was being discussed, is that was envisaged to be a subject to contract agreement. Everything had to be finalised before it was intended. How does agreement on main terms affect that? Why does that make it no longer a subject to contract case?
Well, two parts to that. Of course, what I've said from the beginning is context is everything, and it may be from the whole run of documents, one forms the view it is a subject to contract case. Of course, you could form that view, but that would normally be where the parties have made it clear it's subject to contract, in line with the analogy your lordship put to me.
Well, they don't, in my example, they don't usually.
Well, because everyone, but that's because
They buyer and seller don't say subject to contract.
no,
That's simply the label the law puts on it.
but the label the law puts on house purchases is that they are subject to formal contract. So you don't have to say it. And every communication between the parties is subject to the overlay that in house purchases, nothing is agreed until the contract is signed.
Right.
But each case depends on the context.
I understand that.
And
But
if
my premise is right, that the initial stages were subject to contract, I do not accept that. But if that is the position, why is there a difference between the communications you've been showing us about agreeing main terms and the language of confirmation and agreement, and the example I gave you of a house buyer and house seller agreeing those
because
main
then it's much closer to the RTS case that I showed you, which is where you had a subject to contract, but because of the parties' conduct, the subject fell away. So you could have a position where on the 24th or the 25th, people are saying it's subject to contract, and you could read that. But then on the 26th, when the tugs are about to be engaged, or you're going to lose the main tug, they now say we must agree the main terms because we must agree the remuneration. Then it would be a question as to what the objective observer would think. And there are two possibilities. One is it's still subject to contract, or two, there has been a change. And what we say is that what the judge effectively finds, and he says in his judgment, it is akin to a subject to contract case. And he looks at those earlier communications. And what we say is no, because if you look at the basis of the ultimatum on the 26th and the circumstances, there has been a fundamental change in that they need to get the tugs and they need to get them to site. And because of that, they want the main terms as to remuneration agreed. So even if, which I don't accept the premise, the earlier part was subject to contract, there has been a clear change as at the morning of the 26th, and that ultimatum as to main terms is as to an agreement, i.e. a contract. And that's the reason why I showed you carefully 147, the penultimate paragraph, when they talk about a requested confirmation of either a commercial agreement or LOF. That's not talking about agreeing some of the terms in a negotiation. That is talking about agreeing either an LOF contract or a commercial agreement contract. And that's why 147 is very important as one of the three ultimatums. That the position, whatever it was before, had clearly changed was clearly in the morning that they needed an agreement, because that's what it says. And then I'm conscious I need to keep some time for a reply. I probably don't want to.
You're going on to reflotation.
Yes, the reflotation bonus, the point in that, as I was making in paragraph 70, paragraph 77 of the judgment, the judge deals with that by saying it was contemplated it would be that the whole thing would be sorted on the 26th. But the reflotation is taking place at 3 o'clock Egypt time. You get that in S1 page 194. There's a report from the site that shows the time. That is 1 hour, 20 minutes after the message at 149 saying everything's agreed. And it is, even with people working very hard and being very good English lawyers, inconceivable that everything was going to be agreed in 1 hour, 20 minutes. Because the contract hasn't been discussed and negotiated. Everyone's agreed the main terms. Then it makes sense to refer to this about what's going to happen in 1 hour, 20 minutes if the intention is it's going to be binding.
How long had they had the contract for? About 24 hours.
No, they'd had it at Stan Marine. Sorry, let me go back.
Well,
Sorry, I'll answer your question. Depends.
leave aside for the moment how long, when it had been passed on.
Well, the
How long
owners.
those on the owner's side had the
The
contract terms to
if
consider.
you remember, the owners were given it on the night of the 25th, which would 2140, which would be Japan time early morning on the 29th. But Stan Marine, the English lawyers, got it at 0606, 6 o'clock in the morning on the 26th. And then you have the negotiations about the main terms. So on this basis, Stan Marine would have had to review all this, get instructions and sort it all out in 6 hours flat.
Sorry, could you just give me the
It
page
is actually
reference again?
received. I'm sorry to interrupt. If we look at page 144, when it was sent to Stan Marine told my client Smit, thanks, I have received from Mitsui, so he'd gone sometime before.
Your basic point, Mr. Parsons, is, as I understand it, that there is no urgency demonstrated in the message at 50, which, if there really was a need to do this within an hour and 20 minutes, is that essentially what you're saying?
Yes. So if you then look at (150), there's no sense of urgency, and if you look at what the next the next time when there's any chaser at all is 184. Which is at 1756 UTC. When it's saying, can you indicate when we expect your company's detailed response on the draft letter? So that is 6 hours later. So nothing then happens on that. And then that brings me on to my final 2 points, which is the court has seen the sense of urgency and ultimatums on the morning of the 26th. But we must agree with these things.
Sorry, I'm sorry to slow you down. I just want to get the timing on the reflotation. I think you gave us the reference at page 194.
Yes.
Anticipated reflotation attempts
1500.
as from
1500.
And there's some
That's-
evidence somewhere, I think, as to how long a reflotation attempt would take.
Well,
I think was considered to be a significant period, but I've forgotten where I got that from.
I've seen
We're
reference.
talking hours. We're not talking.
You're talking a couple of hours.
Yeah, I thought it was rather longer. But
Well, one of them-
perhaps you can chase that.
Well,
because
one of them was 2 hours and some of them were longer. Because it depends, yes, but you're not talking about minutes. I agree. You're talking about hours, not minutes. But what you don't see is any, if you look at,
But I understand your point. There's no urgency being indicated in relation to finalisation.
no, because I've shown you the one document that is a chaser. Then after that, it seems to take days between the lawyers and it is never finalised by the time it's refloated on the 29th. There are no more chasers about we must agree this, we must agree that because we otherwise will demobilise. There's no more ultimatums of the sort we were talking about this morning. My friend's going to show you something.
Yes, S1 102, page 200 is a chaser. That's 27th March 0626. We're still awaiting feedback on our contract, which has not been signed, yet
But
here we are.
I think,
Sorry.
Mr. Gaines, we were told about when the first chaser was, which was later that afternoon.
Yes.
But my learned friend, sorry, I don't mean to bicker, I'm so sorry, my lady. My learned friend said there were no further chasers until, and that there is. I'm giving your ladyship the reference.
Well, I apologise if I misspoke. What I meant to say is there's no further ultimatums and sense of urgency that you saw on the morning of the 26th. There's no more threats to demobilise if things aren't agreed. The whole tenor and approach changes after you have these many terms agreed in the morning of the 26th. And the tenor and approach is important because if it really was, the purpose of these ultimatums was that Smits did not want to be exposed. On Smits' case, they remain as exposed in the afternoon of the 26th and the 27th and the 28th and the morning of the 29th as they were in the morning of the 26th. And yet you do not see any more ultimatums of this form.
I'm sorry to slow you down, but is there any evidence as to when the reflotation attempt in fact took place? Because Smiths have got someone on the ground, as it were.
Yeah.
we've seen in reference to what I think in the morning was anticipated as being as from 1500. But do we know?
I'll chase that down over lunch. And so we don't get more ultimatums, nor do we get any demobilisation. So we submit that all of the tenor and the tone thereafter is completely different.
Sorry, at just at the annex, A147, 1305, the vessel was successfully refloated.
But that's on the 29th.
Yes.
I think what your lordship wanted to know was on the 26th.
Reflotation attempts from
Would you
the
like
26th.
From the 5th.
Would you like them on the 27th, 28th as well, or just the 26th? We can check over lunch for that.
I think we better have a look.
I think so.
Yes.
Thanks.
The only concern, 26, was that
If you look at what the concern was on the 26th, was the chartering of the APL guard. The total cost of the APL guard is going to be hundreds of thousands of dollars. That is the main concern on the 26th. Of course, she doesn't then arrive until the morning of the 29th. But you don't get any further ultimatums because, as from the main terms, they now are protected. They are no longer exposed. All the basis of the ultimatum has fallen away. If, on our case, there's a main terms contract. On their case, they're still as exposed. And yet, why do we not see any more ultimatums of the sort we saw earlier? That's really the key point, is on the change of the tenor. So, drawing all that together, we say, in a way, it's a simple case for the court to read the communications and conclude objectively. What does a reasonable person consider? Does the reasonable person consider that there was to be an agreement on the main terms with the wreck hire to be included afterwards, or was it all very just being subject to everything? And we submit that the right answer is that you should conclude that there was a main terms agreement concluded on the noon of the 26th, because the ultimatums are only consistent with the fact that Smiths were insisting on a binding contractual agreement by 12 noon Dutch time, or they would stand down the tugs. Smiths required a contract because they were exposed to very substantial financial costs, with no prospect of recovering those costs on a quantum merit basis. A main terms contract was needed by Smit, given the timing of the reflotation attempt on the 26th, and the fact that there would be subsequent reflotation attempts until those tugs arrived. The time differences between England, Netherlands and Japan meant there was no real prospect of a detailed wreck hire being finalised within a couple of hours that day. The wording of the communications uses contractual language. The terms of the reflotation bonus only make sense if there's a binding agreement, and there was a complete change of tone or tenor in the exchanges, or lack of exchanges, afternoon on the 26th. And finally, Smit performed the bargain that they wanted in their ultimatum. They hired the tugs, they sent them to the casualty, they did not demobilise. That's what they said they would do if they did not have a main terms agreement. And we say for all those reasons, a reasonable person viewing the documents in their context would conclude that there was a main terms agreement. And my lords, unless I can help you further, those are my submissions.
Nothing else. Thank you very much indeed. Yes, Mr. Case.
My lady, my lords, the first question for the court is what approach it should take to the review of the judge's decision. There's no appeal against the manner in which the judge directed himself on the law. Indeed, there was no material dispute at trial on the law. So we're left with what owners in Skeleton Para 7 call a simple question of construction, on which they contend that the judge, quote, fell into obvious error, unquote, surprising as that may seem. We submit that owners are wrong to say that this is a simple question of construction. Of course, it depends what one means by construction, which is a word that can mean different things. But the judge here was not merely examining the meaning or legal effect of a clause in a contract or a simple exchange of letters. He was evaluating a number of moving parts, documents, certainly, conversations, actions, inactions, the whole complicated and changing situation in which the parties found themselves and the surrounding context to determine what inferences and conclusions to draw. And that word evaluation is key. There's very little between the parties on this point. If you look at owner's skeleton, paragraph 41, in your own time, I would suggest, when they say the task of the task of the judge was, quote, interpretation of the evidence, unquote. And they too talk of the commercial context and the importance of evaluating the parties' conduct. So, and this is all because the question for the judge was to determine the parties' actual, albeit objective, intentions, as at late morning. Did they intend, in that sense, then and there to be contractually bound by, and I think it boils down to, the emails at 11:35 and 11:40 on the morning of 26 March. Now, it's unnecessary to spend time debating whether this is a question of law or a question of fact or a mixed question of both, because on the authorities that doesn't matter. What matters, however one defines the question, is that this was an exercise of judgment and evaluation of competing considerations in order for the judge to reach his decision. On the one hand, my learned friend stresses the ultimatums. On the other hand, I stress as I shall show your ladyship and lordships, the commercial proposals. So it's a balancing process of evaluating different factors. It's not a pure question of law or anything like it. And if that is right, then on well-established authority, the judge below is entitled to what Mr. Justice Neuberger calls a margin of appreciation. And that margin applies not just to findings of primary fact, but also to the evaluation of those facts and the inferences to be drawn from them. That's a quotation from Lord Justice Lewison in a case called ACL BDD, Authorities, tab 11 at 29, at paragraph 29, quoting something he'd said in an earlier case. So we rely on Todd and Adam and the ACL BDD case, and also Lord Mance's speech in Datec, for the propositions that in this sort of case, this court should, with respect, not interfere unless compelled to do so, or unless it is satisfied that the judge's conclusion lay outside the bounds within which reasonable disagreement is possible. Your ladyship and your lordships must be satisfied that the judge was plainly wrong, that he reached a conclusion which no reasonable judge could have reached, or which was rationally insupportable. I've given your ladyship and your lordship the three cases, and it's the sidelined passages in those cases, if I can deal with the matter shortly in that way. But I expect that your ladyship and your lordship have a submission or a variant of the submission made to you quite often, so I expect you're pretty familiar with the material.
I think that's probably right.
The present...
Cases cited vary, but the submission
Exactly.
remains the same.
Yes.
Well, one seeks variety where one can.
But what we do know is Lord Justice Lewison always features.
Yes, he does. So much the better. Just picking up a point from Mr. Justice Neuberger in Todd and Adam, what the appellants are doing here is bringing an appeal in the hope that the impression formed by this court will differ from that which was formed by the judge. And that was the practice that was deprecated by Lord Justice Buxton in a case which is cited, if I can put it that way, with approval by Mr. Justice Neuberger. Now, obviously we submit that whatever the test is, the appeal should be dismissed, and I don't want to spend too long on this. What I'd like to do now is to proceed to my main submissions, which are 8 in number, and I will perhaps pick two of them, if I may, before the short adjournment. First, and by way of context, salvors typically do mobilise and render services on speculation. And that is what Smit did here. They talked about what they were doing, in this case, as mobilising proactively. That was the adverb they used, S1, tab 8, page 25 and 25a. And that's what salvors do. Neither mobilisation nor services gives rise to any inference in favour of a contract. The judgment sets this out in paragraph 47, and that, I respectfully submit, is a completely unassailable paragraph. And nothing that happened in this case on the morning of the 26th or otherwise affects that important context. It's really the end, the concluding part of paragraph 47. That's what happens in this world. Now, what happens in non-salvage cases is often completely different. One such non-salvage case, my lady and my lords, one such non-salvage case was the Kernia Dewi, the case of Mr. Justice Clark's. That was a wreck removal case, it wasn't a salvage case. There are two reasons why that case doesn't assist your ladyship and your lordship. The first, that it's not a salvage case, so the facts are different. If you mobilise and if you contribute in salvage, you have a common law reward. You don't need a contract, so that the considerations are different. The second reason why that case is not helpful is because it's not authority for any proposition of law whatever. It's merely a decision that on different facts, a judge of the commercial court, a very distinguished judge of the commercial court, thought that there was a serious question to be tried. Really. It's not what the citation of authority is for. And so that deals, at the outset, that salvage context with owners' reliance on the general statements in the non-salvage cases that performance of services during negotiation of a contract may lead to the inference that the contract has already come into existence. Again, the propositions of law in this area are very few, except, as Lord Clark said in RTS and Müller, everything depends on the circumstances of the individual case, paragraphs 47 and 54. Second, and my second main submission is this, and I'm now coming to the heart of the matter. The answer to this case lies in a careful reading of the parties' key exchanges. Eccentric as it may seem, given my learned friend's approach this morning, I intend to take a chronological approach. The decisive fact is this, that within 24 hours of first learning of the casualty, my clients, Smit, admittedly a first-class international professional salvor, who Captain Sen in evidence described as very professional, stipulated that their relations with owners would be on the terms of a detailed commercial offer. First made, as your ladyship and lordships know, in S1, page 39, and on the following day, superseded by a more detailed one at pages 83 and following. All through that time, from 12:03 on the 24th through to the end of the 25th, there was no difference in approach, although the second offer was more detailed than the first. This proposal, this will be our submission, remained centre stage throughout, and Smit insisted on it. That commercial proposal, the 2140 commercial proposal, was formally reiterated as an offer an hour before the emails upon which the owners rely as constituting a contract. When Mr. Janssens, in that document at email at 10:37, talks about a commercial agreement, the commercial agreement repeating the commercial offer last night and the commercial agreement. In both cases, he says a commercial agreement or LOF. He's talking about the complete contract, and he reiterates that contract, that offer of a contract, on which Smit have always been insisting, as well they might, in this situation with the world watching, an immensely complicated, potentially immensely complicated situation. They reiterate that offer an hour before the emails on which my learned friend relies, and here's the other side of the coin. Owners, for their part, always recognised that it was incumbent upon them to respond to this proposal. On the 25th and the 26th of March, owners' representatives acknowledged in writing no fewer than 7 times the need for them to revert to Smit on their commercial proposal. On all but one of those 7 occasions, using language which recognised that they must do so as soon as possible. Of those 7 emails, 4 came before the alleged contract, 2 contemporaneously with it, 1 after it. It is not surprising, therefore, that the judge found that as of the morning of the 26th of March, an imminent response to this proposal could reasonably have been expected. Paragraph 62. May I just finish this point,
Of course.
if I may? Thank you very much, my lady. Owners challenge, or seek to challenge, the judge's unchallengeable finding that the parties reasonably expected the detailed contract to be concluded promptly after the exchange of emails on the morning of 26 March, and indeed that Smit was seeking signature on the 26th of March. Now, my learned friend, Mr. Parsons, said, oh, you couldn't have expected this to be agreed promptly, meaning the 2140 commercial offer. Well, my lord, my lady and my lords, may I end the morning with the awful fact for the owners, which entirely supports the judge's finding, that Smit's detailed proposal actually was agreed. Shortly after midday UTC, on the 26th of March, by both the owners' managers and by their hull underwriters. The references are judgment, paragraph 69, S. Does your ladyship have tabs in the S bundle?
We do.
Yes. Can I just deal with the tabs then?
Please, that would be helpful.
S, tab 84 and tab 86, and appendix to the judgment A98 to 101. But that agreement was never communicated back to Smit. One can speculate as to why that was, and it's human to do so, but it's irrelevant. It's common ground that it wasn't, and the judge has found that the entire proposal was agreed by Mitsui and by SKK, the vessel's managers. So there was plenty of time. There was always 12 hours to spare. Is that a convenient moment?
Certainly.